Hello, this is Frank Hoyt, President of Midwest Lawyers. We provide professional liability insurance to lawyers throughout Iowa and other Midwestern states. Midwest Lawyers is committed to providing the legal community with the highest quality professional liability coverage combined with the highest level of expertise, advocacy, and service in the marketplace. To us, prevention is just as important as coverage. To that end, we are pleased to provide you with information and legal briefings that are designed to reduce the likelihood of a malpractice claim or ethics issue. We have asked Nick Critelli, past president of the Iowa Bar, to provide you with periodic legal alerts so that you can be aware of significant legal developments that may affect your practice. Nick?
Thanks, Frank. I chose the Humphrey case for today's video law brief because it illustrates the all too familiar situation where a lawyer goes into shutdown mode and can't figure a way out of it. Let's brief the case and then we'll discuss the lessons learned. Suzanne?
Iowa Supreme Court Attorney Discipline Board versus Brian Humphrey, Friday, March 30th, 2012. Humphrey agreed to represent Mr. and Mrs. Victory on an insurance fire damage claim to their home. He took the case on a contingent fee, but failed to reduce the fee agreement to writing. At the start of the representation, he was able to convince the insurance company to provide $6,000 towards the Victory's temporary housing expenses, for which he received a one-third fee. But from October 2008 through March 2010, Humphrey ceased to communicate with the clients. The Victories sent 35 text messages asking for the status of the case, but only received 3 responses. Likewise, the Victories sent a series of certified letters asking for an update, which were also ignored. Finally, the Victories negotiated a settlement directly with the insurance company and filed a complaint with the Attorney Disciplinary Board. At the board hearing, Humphrey admitted that he violated the rule that requires contingent fees to be in writing. He freely admitted that there were times I did not respond to my client. He explained, "I have no evidence to present. I do admit the allegations made against me. I won't try to mitigate what happened by telling you the circumstances." When asked, "Is there anything else in your life or in your practice that you feel would be a mitigating circumstance you would like us to take into account?" Humphrey answered, "Honestly, I wish there were, but there's not. And no, I can't blame anything. No, I don't have any excuses." When asked what, in hindsight, he would have done differently, Humphrey stated that he would have withdrawn from the case. Following the hearing, the Commission imposed a 5-year suspension. On appeal, the Supreme Court noted that the Victories were not financially harmed by Humphrey's neglect, nor did Humphrey financially benefit from his actions. However, the court was quite critical about Humphrey's indifference to the Victories' pleas for communication. The court noted that the Humphreys' incomplete and severely delayed actions do not comply with the Rule 32 1.3 standard requiring a lawyer to act with reasonable diligence and promptness in representing a client. This lack of communication violated Rule 32 1.4 sub a sub 3, requiring an attorney to keep the client reasonably informed about the status of the matter. Rule 32 1.4 a sub 4 obligates a lawyer to take the initiative to keep the client informed. By promptly complying with reasonable requests for information, Humphrey did not do so. The court noted that the Victories' informational requests were numerous, explicit, and reasonable, yet Humphrey ignored nearly all of them for at least 17 months. Justice Manfield identified the core violation committed by Humphrey as neglect of a client matter. He noted that neglect is not specifically defined in the Iowa Rule of Professional Conduct, but noted that it has generally been recognized to involve indifference and a consistent failure to perform those obligations that a lawyer has assumed, or a conscious disregard for the responsibilities a lawyer owes to a client. In this context, he distinguished neglect from ordinary negligence. Neglect goes beyond ordinary negligence and is a form of professional incompetence that often involves procrastination, such as a lawyer doing little or nothing to advance the interests of a client after agreeing to represent the client. Based largely on the fact that the victories were not financially harmed by Humphrey's neglect, the Supreme Court reduced the suspension to 3 months.
Now, Mr. Humphrey truthfully responded that he had no excuse for the procrastination. That's common in this type of situation. Lawyers know what they should do and the consequences of not doing it, but they just can't seem to do anything. They're emotionally paralyzed and can't figure a way out. I call it situational overwhelm. Now, don't think that you're immune from it. It could and has happened to all of us at one time or another. Let me give you the common denominator. Someone or something else is in control and it's not you. Could be a client who makes incessant demands. It could be opposing counsel who's using the offense tactic of push and then demand. Or it simply could be the complexity of the matter, too many documents, a new or complex area of the law, and you just can't find the energy to get into the case. What results is approach avoidance. Now remember, situational overwhelm causes approach avoidance, which creates a crisis situation. The good news is that there is a solution and a way to prevent it from happening or manage it once it does happen. The prevention part is called contingency planning. The response part is called crisis management. Now, some of you know these terms and techniques as they relate to natural disasters, floods, hurricanes, and so forth. But I'm here to tell you that they work equally well with regard to your law practice. You just have to understand them and adapt them to your individual situation. So here's how it works. Let's talk about prevention contingency planning first. First, identify the situation that could cause a loss of control. List them out and think about how they could cause the crisis for you. Now, for each situation, create a tactical response plan that will either avoid the situation from occurring in the first place or allow you to regain control of the situation. Take demanding clients as an example. This is not a negative thing. If managed correctly, it can be quite positive for you. Clients are demanding because they have a great deal of interest in their case. They want to be part of the team. Instead of complaining, make them part of the team. After all, it is their case, and they know it better than anyone. Once on the team, give them something meaningful to do. If the situation is case complexity, either because the law is complex, too many documents, too much research, etc., bring in co-counsel. To them, your complex matter is routine. Or if an opponent is using the push and demand tactic, develop countermeasures that further the strategic plan of your case. Don't have a strategic plan? That's probably the root of your problem. Bottom line, foreseeability and contingency planning can minimize the chance of crisis, but it can't stop all of them. Once a crisis develops, you have to figure out a way to get control. There are two parts to crisis management, and both concern control. A crisis, by definition, is a situation that's gotten out of control. The first rule of crisis management, get control. Timing is critical. The quicker you regain control, the less damage you will suffer. How do you regain control? Simply identify the root cause of the crisis. If it's one of the situations you've identified in your contingency plan, implement the plan. But if it's a new or unforeseen situation and you are in the middle of it, apply rule number 2 of crisis management. Reach out for help. You will need a fresh set of eyes to work you through it. Keep in mind, the mere fact that you are in crisis means that you are overwhelmed, and your thinking will be muddled. Always have an outside source you can run to. We're a collaborative profession. Reach out for help. As always, if I can be of help to you, simply call. This is Nick Critelli in Des Moines. Thank you for watching.
Thank you, Nick, for that update. If there are areas of the law that you want covered, please let me know. We're here to serve you. Remember, an ounce of prevention is worth a pound of cure. Thank you on behalf of Midwest Lawyers.